Good morning from Singapore. My name is Ratu Nafisah. I am the Research Associate at the Center for Asian Legal Studies at NUS Law, and I will be your moderator for today. On behalf of CALS and our director, Professor Jacqueline Neal, I would like to extend a warm welcome to all of you for joining this webinar. So this event is part of the virtual roundtable series on Asian law that the center has started since during the pandemics, and we have since continued aimed at further broadening our discussions and exchanging views on law and legal developments in Asia. Before we start our discussions, I want to extend a special welcome to Dr. Dian Shah, my mentor, who has recently taken a new role as Deputy Director of the Center. So Dian was our postdoc and our research fellow previously at the centers. And it's my pleasure, Dian, to welcome you back here as a speaker in your new role.
Thank you, Ratu, for mentioning that. I start in a couple of months, but yeah, it's nice to be back at the center.
Fantastic. All right. So today's topic is very special as we will be discussing 20 years of the Indonesian Constitutional Court. Over the past 20 years since democratic transition, Indonesia's Constitutional Court has played a key role in facilitating democratic consolidations and emerged as one of the most significant institutions in the country. We hope to discuss, to reflect on the challenges, milestones, and impact the court has had on Indonesia's democracy and rule of law in general. To this end, we're grateful for having such a fantastic panel. So you could find the detailed bio of our panelists at CAL's social media and in the registration links. The first speakers we have today is Dr. Stefanus Hendrianto. Dr. Stefanus Hendrianto is a lecturer at the Pontifical Gregorian University, Italy, and an incoming Waite Chair Professor at Creighton University, United States. Dr. Hendrianto holds a PhD in law from University of Washington. The second speaker is my mentor here at NUS, Dr. Dian Shah. Dr. Dian Shah is an assistant professor at NUS Law and our new co-director at the center. Dian completed her SGD degrees at Duke University, the United States. We have another Dian for this virtual roundtables. It's Dr. Dian Rositawati. Dr. Rositawati is the Indonesia Programs Director at the Stanford Center for Human Rights and International Justice. She teaches both at University of Indonesia and Gentera School of Law and has completed her PhD at University of Tilburg, Netherlands. And last but not least, I'm very grateful for having my teacher and undergrad supervisor, Prof. Susi Harijanti. Prof. Susi is a professor in constitutional law and director of constitutional law department at Padjadjaran University, Indonesia, and she obtained her PhD degree from Melbourne Law School, Australia. So each speaker will have 15 minutes for their presentations, and we will be reserving the last 25 minutes or so for questions and answer. For the audience, please use the Q&A functions on Zoom for submitting your questions, and I will read them out during our Q&A session. So without further ado, Dr. Hendrianto, the floor is yours.
Good morning, and thank you for NUS and Center for Legal Studies for sharing opportunity this morning. So we will discuss how that the court survived the second decade of its existence. So we'll start, I think, with the questions. I think that how do we get, where we are now? That the court after 20 years, more than 20 years now. So I'll say that we are now in the third and fourth generation court. Why I use the term 3rd/4th, because there's some justice that it's been there for a while, from at least 2015, so they're part 3rd generation justices. But there's some new justice also that who came to the bench recently, so they're part of 4th generation. So this current court is a kind of combo between the 3rd and 4th generation court. But regardless where they're coming from, I think what happened in the last 10 years, there's erosion of responsive judicial review or heroic judicial review, which started in 3rd generation under the chairmanship of Arif Hidayat, followed by chairmanship of Arwah Usman, and currently under leadership of Chief Justice Suhartoyo. Pretty much the court has retreated further away from its heroic rule in the 1st and 2nd generation court. So that where we are today, I think that, so basically that they are moving toward an unresponsive and unheroic court that I like to describe the current court. So we'll look today that in history, Indonesia began to experience some democratic decline, marked with deliberate democratic blockages, and the court failed to be responsive to this, at least the 3 forms of democratic dysfunctions in the country. So it's anti-democratic monopolized power by Jokowi regimes, and some democratic blind spot in the area of elections, and so democratic burden of inertia in the area of things that human rights and Bill of Rights. I'll explain further about that. Basically, the court has failed to be a hero that can fix democratic dysfunction, but instead, the court itself has become the villain in some way that contributed to the problem today. So, as I mentioned before, that the court also failed to address many issues that part legacy of authoritarian constitutionalism in the country. We can see that there's a huge gap in some area of jurisprudence concerning freedom of expressions, freedom of worship, religious freedoms. So far, I think that Dian can speak more about this, but in my observation, I think that the record is pretty bleak in this area. Property rights also almost zero. Socioeconomic rights is dubious record also. First 10 years, maybe, that quite okay, but the last 10 years is kind of pretty, bad, the record itself. Human dignity is absent from court jurisprudence, and other areas like environmental rights also, there's nowhere to be found also in the court jurisprudence. So that's where we are today, I think that after 20 years. And how do we get here? There are many problems, and there's many factors, but I'll focus only one issue today. I believe that the rest of the speaker will talk many different aspects of the challenges, but I'll speak only one aspect, which is I think that the composition of the justices, the who fill the benches. That's the issue. Because mostly in the last 10 years that we only have mediocre judges. Why I call it mediocre judges? Because they are intellectually weak in many different ways. To put it simple, the lack of knowledge of constitutional law. Those justices, they are trained locally in pretty much the same things that training ground, and I think that they just learn how to to see the issue from perspective the all hukum tata negara, which is mean that things that not really constitutional law per se, but rather things that how that the state should be governed, which is they inherited from Dutch Staatsrecht. Not constitutional law in the sense they learn really about constitutional cases and constitutional adjudication. So that those who fill the benches in the last 10 years. So I will describe them pretty much judicial soldiers who simply I think serve the interests of the state apparatus or those who appointed them. The problem is we have limited pool of judges, so they lack available pool of talent. There are few who are talented judges, and they have some knowledge of constitutional studies, but they didn't have a chance to go to the court of being appointed, or among the few, very minority, I think that in the court these days. So this issue of tenure, which can be a curse and blessings. Currently that you have 15 years tenure and then mandatory retirement 70 years old. It can be blessings because this is now judicial independence can be more secure. The justice will not be afraid to be removed or not be reappointed every 5 years, like the previous rule. But it can be a curse. You have bad justices, you stuck with him or her for a while, for 15 years or until he or she retired. So that's where we are now. I think that, and also I think that this is what happened with the recent case that we see, that cases regarding the 2004 to 2024 presidential election. There's one infamous case that minimum age requirement for vice presidential candidate. Some of you already know that the court removed age requirement for president's son. And then there's a breach judicial canon judicial ethics by the Chief Justice Anwar Usman, because he did not recuse himself, as he's the uncle, he's the brother-in-law of Jokowi, which is he's the uncle of the vice presidential candidate, which is, I think, his decision is beneficial for his nephew. Then he was removed as Chief Justice. But most jarring about this case is that despite, I think, that removal of Justice Anwar Usman, the court refused to correct its decision or overturn decision, not only for one occasions, but also, I think, in recent occasion. The court should be aware this is false majority, a plurality decision, that only 3 justices, 2 concurring opinion, which is, I think, that in some way have been concurring in part and dissenting in part. So in the end, I think they let, that President's son to run as vice president's candidate. So in the last case, I think, which is decided last week on the presidential election dispute, the court refused to correct its decision again, and did not touch even the subject of the nomination of vice president's son. But what happened in this case, I think, is kind of, culmination of the judicial reputation of court really tarnished, because the court really ceased to become a knowledge institutions. The court majority refused really, to look, I think, beyond things that what they know so far. I think that they simply adjudicate the case from perspective of rule of evidence in criminal case, instead of looking the case from constitutional adjudication perspective. The court rejected the petition of irregularity of election simply because they say that, okay, there's no proof, there's no solid evidence. They're just using criminal rule of evidence, which is, I think, that cannot be applied in the constitutional adjudication. And the court failed to bring new hope. The court simply rejected the petitions, so they have opportunity to build their reputations, but instead they're making a new drama out of the crisis already in the court. There's the lack of the leadership by the current chairman of court, Chief Justice Suhartoyo. Some people, I think, put hope in him, but in the end, he just only judicial soldier who, I think, looked at the case in narrow-minded approach. So I can say that the court reputation being tarnished and the court has been compromised. Its integrity has been compromised by Jokowi regimes. So I think the future is quite bleak. I'm too pessimistic here, but that's where we are now. I think that, and we are at this point already. So looking ahead, where do we go from here? Looking at the court under the new president, Prabowo Subianto, whether he will intervene through judicial vacancies, maybe yes, maybe no, because he only 2 vacancies 2026, but not president's appointee, one by Supreme Court and the other one by House Representative. But it's possible, logo, that presidents might recall few justices that he thought that did not serve his interests. This is, what the House did 2 years ago to one of the justices. He's being removed even though he hasn't finished his term yet. So Prabowo might do the same thing, but who knows? Judicial interference, again, maybe yes, maybe no, because I think that there's some, already agenda in the House to curtail the authority of the court. It's been a few years. He need maybe push it, but I don't think he need to do that, because what we have now, what I call it, zombie apocalypse court. The court's pretty much already dead, but still alive in some way, and can be dangerous and spreading the poisons, because dangerous to democracy itself, because I think the constitution has been curtailed, lost its function basically, and the court has lost significant power I mean, because they self-inflicting wound. So in this case, I think that Prabowo doesn't need really to intervene too much. He just, I mean, let this zombie court just walking around like that. It will do some harm to democracy and benefit for him. So how does it look like the future? Prabowo most likely will return to authoritarian constitutionalism. The court cannot be taken seriously anymore. It's become a joke now. I think that even I think that it's not funny joke any longer. They will, in certain instances, I think issue some maybe that what it look good. I mean, cases like what happened in the last 6 months. There's few cases that seems I mean giving hope, but if you look carefully, I think it's only pragmatic approach in the sense they want to show that okay, we're doing something here, but in the end, some good cases will be dismissed, and I think they will serve the interest only. I think that the new regime here under Prabowo Subianto. So just in conclusion, I think I just want to quote something from Tocqueville here. I think that Alexis de Tocqueville, he say American aristocracy can be seen from the judges because they are the part of superior political class. They're part of the elite. So I think that if we see from this is not the case in Indonesia, then we know where we are now. Because to have a heroic court, a responsive court, you need a good judges, a good capacity judges. Heroic judging, responsive judging require authorship, tone, and narrative. It requires a court to be filled with judges who can write opinion that craft in a good manner and mix with global local values in their reasonings. And this is what missing from the Indonesian Constitutional Court in the last 10 years and when they come its second decade. I think so. That's where we are now. Okay, I will stop here. I think then we'll let the next presenter to explore further.
Thank you, Dr. Hendrianto. That's a very interesting presentation, especially for the use of responsive judicial review from Ross. I think not many constitutional scholars have reflected using that indicator. So I'll be interested in exploring there more in our discussions. I'll hand over the screen to Dian.
Good morning, everyone. I hope you can hear me well. I want to first thank the team here at CALS. I don't have any fancy slides, so you're just going to have to be content with looking at my face. I want to first thank the team here at CALS, particularly Raisa Vakil for putting together this roundtable, Ratu for moderating the session today, and Momoka for diligently organizing the logistics and technical matters, and also on behalf of CALS. Thank you to all the panelists for agreeing to join this discussion to commemorate 20 years of the establishment of the Indonesian Constitutional Court. I believe the discussion is timely, especially given events surrounding the court in the last year or so, and following its verdict most recently on Monday on the election dispute. Now, for my part today, I won't be discussing specific decisions of the court in any great detail. Perhaps there will be other panelists who will do that, but I want to focus on the court as an institution. And to that end, I will raise a few points on the constitutional politics and political process involving and surrounding the court. Perhaps this will then spur more conversation and attention on the habits, values, ideologies, and principles of the court over time. The first point that I want to raise here concerns the context in which the Constitutional Court was officially established in 2003, with some references to issues of design. On the back of, it was established obviously on the back of the political instability and constitutional crisis surrounding President Gus Dur's impeachment. And then of course there was 4 years of constitutional reforms from 1999 to 2002. And the country was still relatively fresh out of more than 3 decades of authoritarian rule, where the rule of law, judicial independence was virtually non-existent, in part due to the ideological tools and indoctrination invoked to justify the suppression of any institutional checks and balances against state power. And in fact, I think if some of us recall here, several observers had actually labeled the state of the Indonesian judiciary as one of the worst in Asia. So I think this context should be borne in mind as we reflect on 20 years of the Constitutional Court and its prospects going forward. On more specific reasons for establishing the Indonesian Constitutional Court, the provision of judicial or constitutional review, like the Bill of Rights, this is by now a standard feature of democratic constitutions globally. Now, by many accounts, the impeachment saga triggered serious and urgent discussions on the need for a constitutional court, although the idea had already been floating well before the Wahid impeachment debacle came to light, especially given constitutional court developments elsewhere in the region, such as Korea, Thailand, and so on. So my point here is that the confluence of factors, in my opinion at least, is important in thinking about the establishment and the subsequent operation of the court as part of Indonesia's constitutional commitment to democracy. On the one hand, I think there are reasons to question whether there was an unequivocal, genuine commitment to or appreciation of judicial or constitutional review as a mechanism to limit state power. I think, Henry, in one of your works, you highlighted that during the constitutional reforms process, initially at least, no major political party supported judicial review. But after Wahid's impeachment, then parties began to be convinced of the need for an impartial institution to oversee impeachment processes and resolve disputes between state institutions. In other accounts, some political elites supported some substantial democratic reforms, including the establishment of the court, to essentially save their power and influence at that particular moment in time, given the wave or the direction in which Indonesia was moving into politically. But on the other hand, of course, there were those who advocated for the establishment of a new separate institution to deal with constitutional matters owing to the structural issues with the existing Supreme Court, as well as perhaps the desire to create an institution that represented a breakaway from the troubled past of the Indonesian judiciary. And in this regard, I certainly do not deny that the creation of the court is a huge step forward in the building and consolidation of Indonesia's constitutional democracy. But I do think the result of this confluence of factors that I've just laid out is reflected in the compromises made about the court's jurisdiction, which also shapes its authority and performance over time within the broader legal and political landscape. And maybe, just maybe, the hesitancy, uncertainty, and trepidation around the creation of a court initially among political elites meant that the court's authority and performance becomes very much dependent on the judicial leadership and strategies within the court itself over time. And that has become a key factor in shaping how the court also functions. The second point that I want to raise concerns the challenges surrounding the court. In particular, the challenge of getting the Constitutional Court and the meaningful role that it can play in strengthening a constitutional democracy, getting it not only off the ground, but soaring upwards and maintaining its flight path, given the authoritarian baggage, the weak rule of law, and the lack or absence of judicial independence. Some of the challenges have been obvious as we look back at the history of the court. I want to highlight three here. First, corruption and standards of judicial ethics. The susceptibility of judges to corruption and violation of judicial ethics. This appears to be a recurring challenge within the court. Most notably, in the past decade or slightly more than a decade or so ago, the conviction of Akil Mokhtar and Patrialis Akbar, this raised questions about whether this new institution is truly able to craft a separate and different trajectory from the troubled past of the Indonesian judiciary that I spoke about earlier. In this regard, I do think that the establishment of the Honor Council and the Ethics Council has been significant in terms of instituting mechanisms for self-regulation and maintaining independence from other branches of government. So that's the first challenge. The second concerns the prospects of governmental backlash. And I think if we look at the history of the court, these prospects of governmental backlash are very much real rather than imagined. And here, one form of backlash has come in the form of public criticisms, strong public criticisms by political elites of courts, the court's decisions. President Yudhoyono, for instance, had done so on a number of occasions during his tenure as president. Backlash has also been evident in various instances of government resistance to the court's decisions. For example, it has been well documented that the government had actively sought ways to circumvent the court's decisions or rulings on particular statutes by not only enacting new statutes or regulations, but also enacting new regulations that are beyond the court's judicial review purview. Of course, this machinations, if I can put it that way, it's not unique to Indonesia. Other countries in the region exhibit similar struggles to cement the rule of law, to provide that meaning to the idea of constitutional supremacy, and to navigate the fractious institutional politics between different branches of government. I'll give one very recent example from Malaysia, where the highest court, the federal court, declared unconstitutional certain provisions of the Sharia criminal enactment from the state of Kelantan, but the state legislative assembly almost immediately proceeded to table the same provisions again and to pass them again in the legislative assembly. So that's one comparative example. But what's instructive about the Indonesian experience, again, aside from the machinations and resistance by political elites, is what some might see as a flaw in institutional design. The court is only empowered to review the constitutionality of statutes, and this loophole affords political elites an avenue to circumvent and perhaps even undermine the court's authoritativeness in guarding the constitution and in enforcing limits on government power. Now, the last point that I want to highlight here with regard to the challenges that the court has faced and may continue to face going forward is further attempts or interventions, whether by legislative or executive action, to weaken its institutional integrity. I think it is worth being mindful of the fact that the Constitutional Court law has been amended at least 3 times, one of which involves amendments to the term of office for judges and the composition of the court's honor council. I think Hendry earlier also alluded to this. Some, of course, have seen this as a form of a threat to the independence of the court. Others, meanwhile, see these amendments as a means of insulating judges from potential retribution from the legislature or the executive for its unfavorable decisions. I think the tangible effect of these amendments are currently open to debate, and we are perhaps beginning to see them slowly. But that said, it is important to view these amendments in context of the broader efforts by the government with its control over the legislature, especially in the last 10 years, to undermine the strength and operation of not just the court, but various accountability institutions in the country. And therefore, there is some reason to be wary of these sorts of amendments, especially when we consider also recent issues involving the swift removal of a judge in 2022 and serious breaches of code of ethics by the former Chief Justice last year. These are the sorts of issues that indicate that the court is in for challenging times ahead, and that may erode the morale within the court as well as the public confidence in the court. I'm running out of time here, so I want to offer some closing thoughts. I think that the challenges that the court faces are not uncommon or unique. If we look at some of the regional and global patterns involving threats to judicial independence. I also think that courts go through an ebb and flow in terms of its strength, authority, and performance. The Indonesian Constitutional Court has certainly seen better days in this respects. But it's not just about what judges or the court must do or can do going forward. Sometimes I think it's easy to say the court must do this or that. Of course, we can discuss about how judges might perform their roles better, about appointing individuals with superior aptitude and integrity, engaging in reforms to the constitutional court law to strengthen, at least formally, the court as an institution. I think all these are plausible points to discuss. But while we talk about this, I think it's crucial to discuss the political ecosystem that the court finds itself in, because this will help us better understand the pressures that shape the court's integrity and operation and how it responds to those factors around them. For me, there are no quick fixes or solutions here, but there are several things that those committed to a strong constitutional democracy ought to be mindful about going forward. The first is the ever-expanding toolkit of authoritarians or would-be authoritarians to weaken institutional checks and balances. I think nowadays we won't, at least in the case of Indonesia, I don't think we will encounter a situation where the court will be abolished, but because that would be so jarring and so extreme. But in terms of the toolkits of authoritarians, I think certainly there will be attempts to undermine the integrity and the role of the court going forward. And my last point, which follows from the first, is to get us to think about the habits that are plaguing constitutional politics in Indonesia, namely the resistance to limitations of power, and enforcement of those limitations by independent institutions, including the court, and the tendencies to concentrate authority in one or selected political personalities or oligarchs. These are some of the things that are part and parcel of the political ecosystem that I talked about earlier that the court will continue to operate in moving forward. And I think an understanding of this is key to thinking about how we might at least understand the choices or the decisions and the constraints faced by the court in the years to come. I'll stop there and I look forward to the discussion in a moment. Thank you. Thank you.
Thank you so much, Dian, for outlining the challenges, especially in the context of constitutional politics and judicial politics of the court. Now I will hand over the screen to Dr. Rositawati.
It's a very nice morning when we can hear all these challenges lie out on the Constitutional Court of Indonesia, especially this past weeks has been quite frustrating for some of Indonesian. But let me open my presentation with a story that I experienced back in 2013. At that time, I have a paper that was written in 2012 on the reflections of legal institutional reform in Indonesia, and it was quoted by several media, which I argue about the declining of some institutions that established right after the Indonesian Reformasi. So it's also include Constitutional Court and also the Anti-Corruption Commission and also the Judicial Commission, like some of the example. By saying that Constitutional Court was already having an internal and external challenges and indicated of having corruption issues. So we already discussed about corruption of Constitutional Court back then in 2000, around 2010 something. But the media coverage at the time seemed quite hurt when we're criticizing about Constitutional Court, because the media sentiment was so strong in supporting the Constitutional Court. And even at the time, the Chief Justice of the Constitutional Court gave response to the media saying that he's ready to publicly challenge the argument that Constitutional Court is facing a challenge of corruption. But only 4 months after that frenzy media debate, Akil Mukhtar, the Chief Justice, was arrested by the Anti-Corruption Commission for receiving a draft in return for a ruling in a lawsuit on regional election that was at the time being tried. And that's the first blow to the Indonesian judiciary, especially come from the Constitutional Court. For the first time, the highest officer of judiciary was arrested. Even the Mahkamah Agung or the Supreme Court, that was always considered less clean than the Constitutional Court, never have their justices, let alone the Chief Justice, being arrested, not until last year. So what does the story mean to our discussion today? If we look into what's happening to the Constitutional Court since maybe around 2010, what happened to the Constitutional Court today was not so surprising. Of course, is deeply concerning and frustrating. But the question is that what happened this day, is it a matter of politics, or it's also already rooted in the existing institutional problem within the Constitutional Court? That this decline actually already can be tracked from more than 10 years ago, and what happened this day is just a culmination of whatever has been going on within the Constitutional Court. So my presentation today, I'll be using a yardstick, the legitimacy concept, which I will elaborate first, the concept of legitimacy that I'm going to use to unpack the Constitutional Court. So what is legitimacy? We're discussing about the legitimacy of Constitutional Court currently nowadays. We are having sort of a declining of the public trust to the Constitutional Court. But what is the legitimacy means, and what are the difference between legitimacy and public trust? So as mentioned earlier in my elaboration, that this institution is actually fueled by public support. So this is one of the character of some of the institution in Indonesia that established post-reformasi, is that the public support to the institution is really strong. So before the series of what I call can be called as attack to the Constitutional Court happened in the last 2 years, the recall of Justice Aswanto, the ethical trial of Justice Usman, and the series of judgment, including the yesterday judgment of the Valentine Day's election. In general, the Constitutional Court, with its ups and downs, still at the time until probably like this past month, still considered by public as a trusted judicial organization. However, normally public trust toward a judiciary can only be captured some of the issues that appear to the public, where there are also lots of issues underneath, some already being mentioned by Pak Hendrianto and by Dian, which drive the performance of the court. Furthermore, using public trust to assess judiciary can also be problematic since the opinion of public toward the judiciary in general will be divided into two parts: the opinion that's supporting the winning party and the support to the losing party. I checked this morning, the data from Indonesia indicators shows the domination of negative sentiments toward the last constitutional court decisions on the election with 48% of negative sentiment. However, there are still 28% that give neutral response and 25% giving a positive comments on those court decisions. So how we can assess the legitimacy of court and what's the difference between the concept of public trust and legitimacy? So basically the concept of legitimacy, according to Michel Lesser on his writing back in 2007, is connected between the justifications of the position and functioning of the courts or the judiciary as a whole, both for the party involved, the citizen, the society at large. So legitimacy is basically the the whole factors that justify the trust or the ground of the public trust. So there are two sources of legitimacy: the input legitimacy, which have things to do with the organizational side or the institutional side, the input factors legitimacy. So let's say, for example, the recruitment and selections of the judges, the independence of the judiciary, the management of the judicial organization, or as Dian say, like including the design of the organization, which will be really important on defining whether this organization will be successful or not. And the output factors, which is the product of the court, the decisions and their motivations and how the decision communicate to the parties involved. So I will start with the output legitimacy because that's some of the product that always been praised or criticized by public. So for many reasons, I think this is the strongest source of legitimacy of constitutional court. Although we can say that we are here almost agree, like at least the two previous speakers, that constitutional court decision is considered as not protecting freedom of expression, freedom of religions, and there are many absence on the role of constitutional court and in guarding constitutions. But in general, public still really much support the constitutional court. Even I talked to some of the academic in Indonesia, the glorifications of the constitutional court still there. But however, in some decision that receive positive sentiment, when we read carefully about the legal reasoning, sometimes it's just not legally sound, of course. Let us took some sample of the decisions of the Constitutional Court. The length of the decision suggests an extensive, discussion and debate. Like I just read the last Constitutional Court decision is like 1,700 pages. Of course, not all of those are the legal reasoning, but also like the evidence and everything. But if we compare to the length of reasoning to other judiciary, the neighbor judiciary, the Supreme Court, in which the reasoning is really short, maybe only like 1 or 2 paragraphs. But the issue is that not like the length of the legal reasoning not always reflect on how the positions of the Constitutional Court actually in trying to protect the constitutional rights. So for example, like in some court decision, there is also like a disconnection between what's the reasoning and the judgment. So there is a length of reasoning that looks good, or maybe just put there as, indication that there is a good or, sounds legal reasoning. But on the judgment or the verdict, sometimes it's just really there's a disconnection. That's we can see, for example, on the judicial review on law on the state budget or some court decisions related to the judicial independence in some of the case in which the judicial review between the Supreme Court and the Judicial Commission overlap authority. So some of them, if you look at the legal reasoning, it looks good, but then at the end, it doesn't seem connected between the legal reasoning and the verdict. So, and in the judgment of the general election that was just decided 2 days ago, we can also see that the way the judges argue on those cases is always looks like a formalistic way of deciding cases. So like hiding behind what's already existing in the laws, but not really dare to interpret more. Of course, is that can be influenced by many factors, including politics. But it just shows that the legal reasonings of the Constitutional Court judgment doesn't actually reflect the sounds of a legal judgment. And in some cases, even the Constitutional Court decide some of the issues that actually against the principle of nemo iudec in causa sua, that no one should make judgment in his judge in his or her own cause or the rules against bias. So there are also some cases in which the Constitutional Court decide cases that favor on his or her their interest. So this is also like give impact, of course, to the input legitimacy as well, especially when they decide about the authority of the judicial commission, which then create the issues in which there is absence of supervision within the Constitutional Court, because the Constitutional Court declared that judicial commission no longer have the authority to supervise or do supervision to the Constitutional Court justices. And also when it's the amendment by establishing the honorary ethic councils of the Constitutional Court, in which the composition also include the Constitutional Court, they once again rules against the composition in which then the Judicial Commission no longer can be part of the ethical commissions of the Constitutional Court. So that's some of the example of the output legitimacy, which quite problematic in terms of the court decision. And turning from the output to the input factor from which the Constitutional Court draw its legitimacy, the most important source of the course of the independence of the judiciary, of course, is the individual judges. So just like Hendry already mentioned, also about the composition and how the judges is appointed is also one of the issues and the challenges that are faced by the Constitutional Court. The debates over the risk of politicization over the selections of Constitutional Court appointment actually has been happening perhaps since the first generations of the Constitutional Court. In all generations of the court, it's end up always with the mixed composition, like mostly politician, academics, and career judges from the Supreme Court or representing the Supreme Court. So although the law requires that the selections of justices shall be implemented in objective, accountable, and transparent manner, but the practice has always been mixed. Each of the pillar, the judiciary, the executive, and legislative, does not seem to apply a standardized mechanism in their selection. For example, the selection of Justice Usman for as a justice representing the Supreme Court was merely at the time based on the leadership decision. So it's just like, okay, transferring Justice Usman from the Supreme Court to the Constitutional Court without any kind of selection whatsoever. So even although we know that Justice Usman objectively does not have constitutional law background or whatever background that actually useful for the Constitutional Court. But the recent appointment of Justice Ridwan Mansur, for example, has been conducted involving external independent experts with more open and also involving external selection team. So there are difference between both of those appointment mechanism. The same process also happening in the legislation on the DPR candidates or also candidate proposed by the executive. There's also no standardized mechanism. But despite the elaborate mechanism at the end, political decision over who's going to be appointed is always being debated. And the similar issue is that merit criteria in which related to the competency of judges was seldom absent. So that's for the selection. And the other issues that I want to flag is about the supervision issues, and also the absence of the arrangement on the conflict of interest. That what's then impacted the issues in which the Justice Usman then faced the trial, but then the decision is disappointed for everyone. So I will conclude my presentation. I think moving forward is the most difficult question. I will not try to answer that. However, I would like to stress two things: that the reform eventually need to focus on the element like input and also output legitimacy. And as Dian also noted about the ecosystem, I think it's that this institution lies on the nexus of those three pillars. Therefore, the successful of this organization eventually depend on how executive, legislative, and the Supreme Court respect the principles of independent judiciary. But because of that, in general, then the future does look uncertain. If we look at the trend and the track of the Constitutional Court, I don't think the future seems promising, and it will still be challenging in the future. So with that, I will conclude my presentation. Thank you, Ratu.
Thank you very much, Dian Rositawati, for highlighting technical challenges that are being very important to be taken into account by the court. And lastly, we have Prof. Susi. The floor is yours.
Good morning, everyone, and thank you for the cast to invite me to join with a very important virtual discussion commemorate 20 years of the Indonesian Constitutional Court. So my presentation, it's about my presentation. I give the title of my presentation is 20 years of the Indonesian Constitutional Court, Where to Go. And I want to start my presentation with this sum of reflection. The first one, I want to say that the problem of public distrust in Indonesia toward the Constitutional Court may be a reflection of the problem of legal system in Indonesia. And if we borrow the Friedman opinion about legal system, it always refers to the three elements. The first one is legal structure, then legal substance, and legal culture. And I think that the three elements also reflected in this discussion, also in my presentation. 2023 is the problematic year for the CC. The first one in March 2023, Judge Guntur Hamzah has been found that he made an ethical violation as a result of his act to change the phrase "dengan demikian" or to ke depan or to forward in the CC decision number 103 of 2022. And then the second is the individual and collective ethical violation, again as a result of the CC decision number 90 of 2023 regarding the presidential age limit. And I think this is for the first time happened in the CC during the history of the CC that all judges has violated ethics, although in the different degree. And as a result, also the removal of Anwar Usman as the Chief Justice because of, again, ethical violation. And then this is the fourth aspect why 2023 is become the problematic year for the CC. That is the continuing parliamentary debate regarding the bill of the CC that may affect the independency of the CC judge. And the way I try to present my presentation is based on my answer to each of question that proposed by the committee. This is the first question, the challenges of the court after its 2-decade existence. And my answer that although the CC still retain the respect of the public and the government, but in my opinion, it is less strong, in particular from the eye of the public, than the previous generation, specifically comparing with the first and second generation, that is the Jimli and Mahfud courts, as Mas Henry just mentioned about how Jimli court as well as Mahfud court is very strong in the early year of the CC. And there are some factors that should be considered why the CC lost public trust. The first one is because the CC verdict or the CC decision in some important cases, both procedural and substantive review. For instance, law on KPK, that is the CC verdict in 2021 or 2020, then law on capital city, law on job creation, law on health, and law on election. So I mentioned this, I mentioned two kinds of review that carried out by the CC, that is the procedural as well as substantive review. And then this, the second factor that can be considered is the current CC decision or verdict on presidential electoral dispute, as well as the ethical violation of the CC judges. And for the second question, in terms of procedural and substantive review, I think the key challenges is the compliance of the lawmakers. And one of the examples of this can be clearly found in the case of the CC decision regarding law on job creation. As the court always claim that this is the innovation of the CC decision or the CC verdict. In that case, the CC handed down its verdict by saying that law on job creation is unconstitutional conditionally. And the CC also gave 2 years for the president as well as the DPR to make an improvement according to the CC decision. And one of the issue that is very important from the CC verdict on law on job creation is the meaningful participation. So in response to the CC decision, the DPR as well as the government then make an amendment to law number 12 of 2011 regarding lawmaking. And in trying to comply with the CC decision, then the lawmakers make an amendment to Article 69 of law number 12 of 2011 to become law number 13 of 2022. But in my opinion, what the lawmakers done so far is not fully comply with the CC decision. Because according to the CC decision, there are 3 kinds of rights in terms of procedural rights in lawmaking. The first one is the right to be heard. Then the second, the right to be considered. And the third, the right to have an explanation. And if we see Article 69 of law number 13 of 2022, but sorry, I just read in Bahasa Indonesia. And according to Article 69, paragraph 1, the lawmaker again ensure the right to be heard by the public in a lawmaking process. However, in the paragraph 6, the lawmakers say that the lawmaker may not oblige, but use the phrase may. So the lawmaker may sum up the public consultation in order to fulfill the right to be heard. And then followed by paragraph 8, which say that the lawmaker again use may rather than oblige to have to provide explanation to the public. So in my opinion, even though the lawmaker tried to respond what the CC decision, but in practice, the lawmaker does not fully complain with the CC decision. And this is the second question. What are the evolving challenges and obstacles that CC might encounter after 2024 general election? I think as a result of the CC decision number 90 and the current decision regarding presidential electoral dispute, institutionally, the CC may be a bit hard and slow to rebuild its reputation. However, this may not be the case for some judges who are able to provide good legal argument or legal reasoning in the CC decision. For instance, in the last decision, this is the case of presidential electoral dispute that we all know 3 judges provide a dissenting opinion. That is Judges Saldi Isra, Judge Ani Nurbaningsih, as well as Judge Arif Hidayat. And this is very important for the CC to improve or to set out a consistent and convincing legal argument every time the CC tried and decide a particular case. And how is the newly president will affect the judicial independence, in particular the CC independence? I think it depends on politics of law of the newly president, which again, in my opinion, based on his vision and mission that he disseminated during the campaign era. And I highlight 2 missions that the newly president proposed. The first one is to strengthen Pancasila ideology, democracy, and human rights. And the second mission is to strengthen political, law, and bureaucracy reforms and to strengthen prevention and eradication of corruption and drugs. So, if we read about all the mission that proposed by the newly president, there is no explicit promise to strengthen the judiciary. And I think this is to some extent, as Henry just said, maybe yes, maybe no. But I think if we put the CC in the context, in particular in the political ecosystem, like Dian mentioned before, it is very, for us or for the public, it's quite worry about the future of the CC for some aspect. And maybe we can discuss later after I answer the second question. How about the future direction and priorities? I think the CC faces at some key issues internally. The first one is a detailed law on procedure. Why this is important? Because law on procedure, currently law on procedure are regulated by the internal constitutional court rules, or we call peraturan Mahkamah Konstitusi. So it is very, in terms of the subject matter of legislation, I think that law on procedure should be regulated in a statute rather than heavily depend on the CC internal rules. And the second important why the CC should develop, or why the law on procedure of the CC should be regulated by a statute, this is to prevent judges to make a frequent discretion dealing with law on procedure. Because if judges often make a discretion, and it prevents the legal certainty in terms of the application of law on procedure. The second internal key issue that faced by the CC is about the capacity of the judges, the individual capacity of the judges. I think Dian Rositawati is already mentioned about this issue. And if we read the last decision that handed down by the CC in presidential electoral dispute, I think that not many judges were able to provide a convincing legal reasoning by using various sources of law. And to some extent, I'm afraid that the legal argument that provided, in particular, in the presidential electoral dispute case, demonstrate that most of the judges are the reflection of the European continental judges, the character of the European continental judges, that is very positivistic. And then the third key issue is the potential ethic problem. And externally, the CC should try to gain public distrust and also prevent to be an object of the politicization through a number of ways, such as lawmaking and filling the judge's position. And again, this is the future direction. The future of the CC will heavily depend on the final decision regarding the debate of the bill on the CC. This is the fourth amendment of law number 24 of 2003, because there is a matter of evaluation of judges. And this is the last slide, issue that to be considered for the future. This is the legal culture, gender approach in the composition of judges, filling the judge position, specifically from the DPR, capacity of judges, then the potential of abusive judicial review, and strengthening public control. Thank you, Ratu, to be patient for my presentation. Thank you.
Fantastic. Thank you so much, Prof. Susi. That's a very interesting presentations for helping us to going through each questions that we have previously proposed. Okay, thank you, everyone. Dian, Shah, and Dr. Rositawati, you may show the video. All right, so we have finished the presentation sessions, and now we're moving to the Q&A sessions. But okay, it seems like we have not had received any questions from the audience, but while we are waiting for the questions, I'll use my privilege as the moderators to trigger some key questions. I think from all the fascinating presentations, I think there are many points of agreements about some key challenges that the Indonesian Constitutional Court has faced for the past 20 years. But let me start, perhaps this is more for Hendrianto from your piece, but I would love to hear from others about this question. So Dr. Hendrianto, I think you mentioned in many of your pieces about the heroic judges, right? And then and you outlined especially the importance of the first and the second generations of the courts for helping or facilitating consolidations through their activist judgment, for instance. I was wondering, considering how we ended up here, the significant declines that we face, do you think some judicial approaches used by the first generations or the second generation of the court has ended up, backfire, and then perhaps they need to slow down a bit at the beginning? Do you think this might be or provide some lessons for us going forward? And I would love to hear others as well about this, shifting approaches, and because the fact that the existing judges today, they rely on some of the judicial tools, some of the reasonings that the first and second generations has relied on. What do you think, Dr. Hendrianto?
Okay. There are two, that theory that we can use to analyze situation. Is first, I think that we can say that what happened in the first generation, first and second generation, is pretty much, I think, kind of the untypical. So the fact that there are two period of leaderships of two chief justices, quite towering and quite heroic, with different style of heroism. So I think that may be exception in the sense, okay, this is only in this one point history they came out like this. So what happened to come to third and fourth generation, maybe this is what we expected. So nothing wrong with them, because this is something that will happen in the day-to-day of the court. But the first and second generation exception, because they are towering judges or heroic judges, and they only come once in history, kind of like that. So this, you can see it like that. But second, also, I think that to your questions, I think that this is related to Dian's point that she raised in her presentation. Because, Dian, you asked a question, I think, that does it mean, because I think the court really, I think, is that the design of the court, and also I think what happened in the political environment really make the court really, rely on judicial leaderships. So the court really function well because I think that there's some judicial, leadership that strong judicial leadership that can steer the court the right directions. So why this is, good point that you raise is because of things that the first and second generation, they have so many limitations. They have so many limitations, and they work and also under many pressure, and they're still pretty much working under the same jurisdiction that they have today. But despite all the limitations, Jim Lee and Mahfoud managed to use what they have, limited role that they have, instead to maximize their role. I think so. This is interesting again. I think so. But then how the question is, that different justice fail to do that in the third and fourth generation. Again, they're related to the capacity, and I think that again they don't have the imagination. Maybe the third or fourth generation. I think that less inclined to see that because of their mistake, as you point out, Ratu, maybe that so that the third and fourth generation received the backlash, because even in the first and second generation, they already received some backlash, but they managed to steer the way, I think, that to navigate around the current at the time. So they survived in the first 10 years. But the second 10 years, I think the court didn't really survive. So I think there's many different factors, the combination of many different factors that make that what we are today. So that's what I can say now. I don't want to speak too much and give the other that speakers.
Very interesting. Yeah, any thoughts about this issue from other speakers, perhaps?
Maybe I can weigh in a bit here. I think the study of judicial behavior is a really interesting one, and there's no way I think we can predict with absolute certainty how judges will react or carry out their roles, or the judicial self-conception of their roles and how that that develops once they're on the court, regardless of their appointing institution and the constraints surrounding them. So I think implicitly that was the point that Henry was trying to get at. I think there is this theory, of course, that in terms of judicial strategies, or the strategic account of judicial behavior, that they do look at or are conscious about the political environment that they're operating in. I think not just in terms of what or how other institutions or branches of government will respond, but also what their predecessors have done, and how that might impact or has impacted on the institution as a whole. Because at the end of the day, I think there may be some consciousness on the part of the judges to also do certain things to preserve the institution in the long run, as opposed to kind of just short-term goals through judicial decision making. So that's the first point. The second point that I think is important to think about, and this relates to what Henry has mentioned earlier, but also sort of more explicitly brought out by Dian Rositawati's presentation, is about the reasoning. And I agree with her completely that the length of reasoning it's not the main issue, but we need to be conscious of the quality of reasoning that's coming out of the court. And perhaps that's one factor that we might look into empirically, right? In thinking about the approaches or the evolution of the court over time, from the first generation to the second generation and beyond. Why I raise this issue about quality of judicial reasoning, because I think quality of judicial reasoning in the decision-making process is a form of judicial accountability. When you don't have quality judicial reasoning, then I think that signals that perhaps that there is an erosion in judicial accountability, both within the court as an institution and also amongst the judges individually. And to relate to that, I think Prof. Susi mentioned about this very formalistic or positivistic way of reasoning or decision making. And I think this is important too. I wonder if the extent to which this is a reflection of Indonesia's civil law tradition, and if this is something that we just, unfortunately, for the lack of a better word, have to wait for this to evolve over time. So those are my thoughts.
Thank you, Dian. Perhaps from Dian Rositawati or Prof. Susi?
Yeah, okay. Can I chime a little bit on the issues of what happened on the first and the second generations of the Constitutional Court? I don't think it's unique to the Constitutional Court, because that also happened with the other legal institution, at least, that established during or right after the reform, which shows that I think the ecosystem of the atmosphere of reform is actually declining, and that shows that the ecosystem is actually doesn't work anymore. So that's also happening with the first and the second generations of the Anti-Corruption Court and the Judicial Commission and also other institutions. So that's, I think, the trends in Indonesia, in which this new institution that we hope can can introduce a new organizational culture, but eventually they become, having a similar problem with the conventional institution that's already been established, like Constitutional Court with the Supreme Court, same Judicial Anti-Corruption Commission with Attorney General Office. as the counterpart also the same. So I think that's also indicate that in terms of system, we don't actually establish what Dian says as a proper design. So it seems like reform can then instantly be conducted after we establish institution, but there are also many technical factors that actually contribute to the success in the long run of an organization. So basically, like some of a simple jargon like merit-based decision making, wherever we maybe already implies like different mechanism, more complicated, more transparent, but decision making remains the same. Still, the political decision making. That's also happened in different organizations. So we might have like a fit and proper test whatsoever, like a complicated process that's so-called participative or transparent. But at the end, it's about the political decision that actually dominate the process. So that's, I think, the observation or why that's also. And the other issues on the procedural law, I totally agree with Professor Susi. And I think the role of academic somehow, I mean, like the discussion or the legal debate of some of the experts on the Constitutional Court, always something that inspiring us. But in a way, the way that Constitutional Court judges rely so much on the expertise and knowledge of the legal experts is also bothering in some ways. Like there are actually the judges that has to have the the ultimate legal knowledge, but at the end they learn from all of those experts. So it's just, I think, in terms of court procedures, that's something need to be considered in how judges in the Constitutional Court should develop their legal argumentation or legal reasoning.
Thank you, Mbak Dian Rositawati. Actually, we have one question also, I think related to our previous discussions. It is about what Prof. Susi mentions. So Prof. Susi mentions about the encoding rules of procedure in a statute. Can the panelists comment or reflect on this aspect, especially with reference to the administrative to the idea of administering justice and how it can be implemented in a way that preserve discretions while guarding against unpredictable or manipulated process. So reflecting about the needs of these procedural code of conducts or in the statutes, and how this can be, can be put in a way that still preserve independence and preventing this manipulated process for the court. And any thoughts, perhaps, Prof. Susi, you would like to start about how the idea of these rules of procedure?
I think that law on procedure is very important for the CC to carry out its function. And from, for example, from the last practice, we know about there are a number of amicus curiae that submitted to the CC in a presidential electoral dispute. And because of there is an absence of law on procedure for regulating this amicus curiae, then I think that a number of amicus curiae that proposed either by individuals such as Henry, as well as by organizations for the future, I think it is very important to establish or to regulate law on procedure in a very quite detail in a statute. And again, if the newly elected president consider the law on procedure as a part of the strengthening of the CC, so I think the government should initiate the bill on law on procedure. But again, I'm quite quite doubt whether the lawmakers will will put a priority on the drafting of law on procedure. So this is my opinion. And how about the subject matter of law on procedure? I think it is better to identify from the CC internal on law on procedure and choose or just select which are the subject matter that should be regulated in a statute. And I just want to ask very brief about the first question. I want to touch the issue of the legal culture that should be developed, because the legal culture is very important. What I mean by legal culture here is the internal culture of the CC and the practices and ideology of the judiciary. I think I don't know to what extent that the judges with the academic background is able to develop or to establish a legal culture that fit with the CC function. Because we know that according to the 1945 Constitution, there are 3 institutions that can propose for the CC judges, that is from the DPR, the President, as well as the Supreme Court. And we don't know how each of the judges make an interaction between them and try to develop a discussion before. I think that when they make a decision, they make by themselves. And I think that they will prevent to discuss with other judges. But I think it is very important that judges in the CC start to develop, start to create a legal culture. And this is important for the people, because in line with the awareness of the civil society or the public, I think they can now make an examination to the CC decision and try to evaluate what is the legal reasoning that proposed by the judges. And from that, then the public can evaluate what kind of legal culture they try to show by the CC judges. Thank you.
Thank you, Prof. Susi. And because we have only 2 minutes left, I think we may not be having more opportunities to answer questions. But let me have some final thoughts, and I will give it all to the floors about any final thoughts from the speakers about these sessions. But I think to me, from the presentations, I can see that there are challenges in terms of the capacity of the judges, in terms of the quality of legal reasonings, the academic credentials, the way they craft the judgments, which seem to be, doable to be reforms. But then this will be or can hardly be realized, because there are second problem, which is the ideas that the fact that there is tendency that the judiciary has been captured, and this is more into the political issues surrounding the court. So perhaps it is not in the futures, perhaps not that the court might not have the capacities, but they may be under control of political regimes, which perhaps give rise to challenges in examining whether they are acting because they are acting in a certain way because they do not have certain capacities, or because they are being captured. So I think that may be a raising challenge for the futures court in the new presidencies, and also considering the political context in which it operates. So any final thoughts for the speakers about this very big issues of the 20 years of the court? Any final thoughts, perhaps just short?
Yeah.
Yeah, maybe just a short one from me. I appreciate and I agree with the points that Prof. Susi and my fellow panelists have brought up earlier. The thing is, I think, in terms of the functioning of the court going forward, that will hinge very much on the commitment of other political elites to strengthening constitutional democracy in Indonesia. Unfortunately, perhaps now, I mean, we talk about crafting procedural laws, which I agree, it's very important to have such, you know, strong procedural laws, but what we're seeing instead is a bill that's kind of being circulated that is not strengthening the court, but undermining a court, and that says something about the commitment to democracy amongst the political elites who can craft these laws, which will then shape how the court functions. So I think that is something to be aware of and to be mindful of. Perhaps the court is in a hole that it's difficult to sort of dig itself out of at the moment, but we hope for better days ahead.
Thank you, Dian. Any other final thoughts?
Let me say maybe quick things that so I think that what funny thing is about the issue of the procedure is that Susi mentioned is the thing that, as at the end what he says, catch-22, because if you give it to the legislator, they may design something, I think, things that really curtail the court. But here the thing is, what happened, I think, last week, I think, or during the proceedings of the this early this week of the Indonesian constitutional election dispute, the petitioner complained, oh, we only have 1 day, I think, is that to argue before the court. Well, actually, that oral argument actually is 1 day is enough. I think, like, U.S. Supreme Court, you doing oral arguments is 1 day. But the issue is not about the 1 day or how many days, because I think this is constitutional adjudication. You don't need, that 1 month to prove everything like that, because this is not criminal proceeding. So I think that, but the court in the end, I think that, as I said before, that giving the, adjudication is based on the criminal procedure, which is, I think, kind of a mismatch. So I think that until they really understand the meaning of constitutional adjudication, I think that we will not go anywhere. I think that because we were stuck in this cycle, that again in the future. And of course, that many other factors are being mentioned by Dian also. Of course, that we Indonesia inherited civil law, and of course the Dutch civil law systems, I think, and have no traditions of, judicial review. But look at the neighboring country, German, they moved beyond that. So Constitutional Court of Germany also managed to do that. So that's become, I think, the challenge for a country like Indonesia.
Yeah. Thank you, Dr. Hendrianto.
Yeah.
Okay, Prof. Susi, yes?
Can I just very short?
Sure.
I just want to say that the CC itself should prevent itself from the object of politicization of the judiciary. So when the court is silent about the amendment of law on CC that extend the tenure of the judges, I think that's one of the reflection that the court itself is not prevented itself from the politicization of the judiciary. So it is very important. So this is in line what Dian say, that there is a very important need to make a individual commitment of each of the judges in terms of carrying out the function of the CC court. And I just want to quote what the Mendes say in his book. He said that the dignity of deliberative constitutional court is not connected with the bells and whistles of the courtroom mystifying liturgies, but with something more pedestrian and meaningful. Thank you.
Thank you, Prof. Susi. And lastly, Mbak Dian.
Yeah, two quick comments. Last comment. First, on the legal culture. I think it's really important to build a discourse outside the constitutional court. There's always an importance of having legal experts inside the court, but in some way, sometimes it's just also have negative influence on reducing the criticism outside the court for some of the academics that become the experts of the constitutional court. So I think building the cultures of the legal traditions of discussing the constitutional court decisions is really important in the long run. And the second one is, I think, building the opportunity from the court decisions that actually given the conditional unconstitutional, in which there should be a follow-up from the DPR, the parliament, or the legislative makers, because that's, I think, the opportunity of having a legal development, like the influence of the court decisions to the legal developments in Indonesia, which now I think being mostly like the missed opportunity that has not been, taken from the court decisions, constitutional court decision that actually give those opportunity for those legislative development. So that's, I think, those 2 points.
Thank you, Mbak Dian. With that, I think we're in the end of our discussions. Thank you very much for all the panelists, for all your important interventions, thoughts, and ideas. I think this is very important. And thank you also for all our participants. And lastly, last but not least, also thank you to Carl's team, in particularly Raisa and Momoka, for putting this together. Last promotions, Dian has hosted a YouTube podcast, and we uploaded that. This is Carl's Chai Chats podcast. We interview judges from all over Asia, and we would like and you could access the podcast on our Spotify and Carl's YouTube account. It's called Carl's Chai Chats. So please have listen to the podcast. Thank you again, everyone, for joining us, and see you in the next roundtable. Bye-bye.